Okay, so it looks like everyone else can hear, so we're going to continue forward. So again, thank you for joining us today, and we're going to go over first the successful bills, the past bills. And so there are some successes in the failed bills I want to point out, because sometimes the failure of a bill that would have threatened public health is a success. But first, I'll talk about House Bill 523, and also known as Senate Bill 119. They were cross-filed, which requires licensing for all those involved in the distribution and sale and manufacture of electronic cigarettes and their component parts. And then Brooke will talk about HB 185, which allows each jurisdiction across the state to issue civil citations for tobacco sales to minors. I know many of you already have that locally, but now everyone has that ability locally. Excuse me. And then I will jump back on and talk a little bit briefly about HB 747, just some modest changes to the CRF, the Cigarette Restitution Fund statute. So for the failed bills, I'm not going to read all of these, but you can see in here what I count as a couple of successes. About 2/3 of the way down, you see the Frederick County and Harford County specific bills. They would have allowed for less coverage for the Clean Indoor Air Act. So those are actually successes that are listed here on the failed bills. Question whether you might consider HB 541 and 474 a success that it failed because it preserves the Cigarette Restitution Fund instead of giving some of the money out for other uses, but the other uses are really important too. So I won't claim that one on either side of the fence. Past bills to get started with ENDS licensing. It creates an entire new title in the Business Regulations Article 16.7. Title 16 is Regulations of Cigarettes, and Title 16.5 is Regulations of OTP, and so this becomes 16.7. It will be effective on October 1st of this year. It requires all businesses that mix or sell electronic nicotine delivery systems, ENDS, electronic cigarettes, e-hookah, etc., or vape liquid, which is specifically included in the definition, to secure a license issued by the clerk of court. Just like with the cigarettes, the licenses are issued by the clerk of court in your particular county. I listed here the fees. As you can see, they're very modest at best. Manufacturer has to pay $25, a wholesaler $150, and a retailer $25, and a vape shop operator $25. I didn't include here, but there is also a storage warehouse operator, and there are differences in the manufacturers for importers versus domestic, but these are the most important numbers for you here. The manufacturer, I just want to point out, is actually anyone who mixes the liquid or puts together any parts of an electronic cigarette. So a lot of the vape shops, and I'll talk about what a vape shop operator is, but a lot of the vape shops are actually also manufacturers because they mix the stuff in their own shop. So if they're mixing in their own shop, they're a manufacturer as well as a vape shop operator. A wholesaler is what a wholesaler is, that pass through, that if they're importing them into this country or they're buying them domestically from manufacturers and then selling them out to retailers. And then retailer is anyone who's selling directly to a consumer. Vape shop operators are those for whom 70% of their revenue comes from the sale of ENDS, which again includes the component parts and the liquid. So a vape shop operator may have to get both a manufacturer license and a retailer license, or they can get the vape shop operator license if they satisfy that criteria. So again, if they're mixing in their own shop, selling directly to consumers, they're either a vape shop operator or they have to get both a manufacturer and a retailer license. So what doesn't happen here? Well, there is a little bit of a caveat, and that is that any entity that is licensed under Title 16 for cigarettes or Title 16.5 for OTP is not required to secure an additional license. They are they're allowed to sell ENDS and vaping liquid with their existing license. What this means is if you have, say, a retailer's license under Title 16, you can sell at retail. If you have a wholesaler's license under 16.5, you can sell ends at wholesale. So you can't cross over, be a manufacturer in Title 16 and sell ends as a retailer in Title 16.7, but you can have that same status under 16.7. This was really an area of compromise between industry and the public health community and the legislators who were supporting this bill, so that there wouldn't be, two things: both a double fee, that they don't have to pay another licensing fee on top of their already terribly onerous $30 that they have to pay, at least at the retail level, but also so that they don't have to actually even fill out another piece of paperwork. That was a really difficult issue for us to manage, working with the legislators who were supporting this bill this session, that just the addition of one more piece of paper seemed to be the straw that would break a business's back. I don't know. We tried to talk about consolidating everything into one form, so it would just be checking another box. But essentially, we didn't prevail in having it be a whole new separate license for those who already have a license under 16.5 or 16.7. The good news is they are still subject to all of the provisions in 16.7. So they don't have to get that license, but they are, with respect to the sale of those products, subject to all of the same restrictions, or prohibitions and requirements. So then the definition of ends, as I indicated, is broadly defined to include the vape liquid and component parts. And vape liquid is covered regardless of whether it contains nicotine. So for a lot of you have been asking questions over the years about how to enforce Health General 24305, which allows you to issue sales to minors violations for ends products if the person was saying it doesn't, if the retailer was saying it doesn't contain nicotine. And many of you have been frustrated with how to respond to that, and we've been equally frustrated with how you should respond to that. So this actually defines vape liquid as not containing nicotine. So regardless of whether they're selling nicotine or nicotine-free vape liquid, they're going to have to receive a license under this provision. Sorry. As with Title 16 and 16.5, the regulatory power is given to the comptroller's office. In fact, I have a call in my inbox from your friend and mine, Ron Gallant, from the comptroller's office, to talk about their office getting ready for undertaking their responsibilities under the new Title 16.7. Importantly, the power to suspend or revoke for fraudulent or deceptive conduct, purchasing from an unlicensed seller, or being convicted of a felony or certain misdemeanors of moral turpitude exists. That includes then, this will allow the comptroller to suspend for sales to minors made in violation of 24-305, as well as for those few counties that have their own end use restrictions. Those would also be able to trigger comptroller action for suspension or revocation. So it's important that really the same standards are used for the sale of ends and the sale of cigarettes and OTP with respect to sales to minors, triggering the ability of the comptroller to take action. The last note here is, I'm sorry, I'm getting over a cold. This will allow for more comprehensive compliance checks and enforcement programs. So from the federal checks that are enforcement program that is done by DHMH's BHA, Behavioral Health Administration, they conduct enforcement programs under the federal law that now include ends, and so, or potentially now include ends, because there is some stuff that's on hold with the FDA under the new administration, but they will be able to at least know where these licensees are. For those of you conducting local enforcement who have wanted to include these locations, you will know where they are and can conduct more compliance. And then for SINAR, they could include, if so desired, these establishments. The caveat here is, if you recall, the fact that the Title 16 and 16.5 licensee holders don't have to get a new license complicates matters a little bit. Again, we would have preferred it to be otherwise, but for the foreseeable future, you should assume that a retailer with a Title 16 cigarette sales license or a Title 16.5 OTP license is also selling ends. So if you want to say I'm doing a comprehensive check of everyone selling ends, you need to include both of those classes because they are authorized to do so. Just want to point that out. But really what it captures for us is those establishments that have popped up through all of our communities that are just selling the vape and the vape liquid, those vape shops. We will know where they are. You can conduct youth checks there. You can go in and communicate with them about what the law is and what your expectations are as a county for their compliance with that law. The last thing I'll address here is whether there's any preemptive effect of the bill, meaning for those of you who have local laws or those of you who might be interested in pursuing local laws that regulate electronic nicotine delivery systems, does this preempt any of that activity? The answer, I think, in short, is with respect to any activity other than licensing, no. It's pretty clear there's language throughout the statute that reflects that the General Assembly is saying, unless inconsistent with local law. So they're really yielding the regulatory power over the use and the sale and purchase of this product, I think, to the local jurisdictions. At least there's nothing in the statute that says they're not doing that, and there's some language that indicates that they are. With respect to licensing, it's a little bit of a different question because they have now comprehensively regulated licensed the field, and given the Altatus decision, the Prince George's County cigar packaging case, it's unclear as to whether local laws that impose licensing for ends sellers would survive challenge on a preemption basis. Again, we don't know the answer to that question, but I think the good news is, if you wanted, for example, to raise the age of access to 21 or prohibit the sale of flavored vape liquid or anything like that at the local level, that this statute does nothing to deter you from doing that from a preemption basis. So on that note, I'm going to turn things over to Brooke to start the civil money penalties discussion.
All right. Good morning, folks. Thanks for being with us today. So I'm going to talk a little bit about HB 185, and that is the civil money penalties bill and now law, which many of you have already heard a little bit about. So what is this civil money penalties? What is this? So HB 185, that creates a statewide civil citation for persons who distribute tobacco products, paraphernalia, or coupons to minors. And it establishes a civil penalty scheme for violations, and it would permit specific individuals in this law to issue the citations to those who violate. It will go into effect October 1, 2017, and it's going to appear as 24307 in the Health General article in the Maryland Annotated Code. So like I mentioned, it is very specific on who may authorize or who is authorized to issue citations for violations here. So county health officers and designees of county health officers are permitted to issue citations. And so a designee of a county health officer is specifically defined as a law enforcement officer employed by a county health officer or an employee of a local health department trained in civil enforcement. So what are the penalties for violating? It is a scheme of $300 for a first violation, $1,000 for a second violation occurring within 24 months of that first, and then $3,000 for each subsequent violation occurring within 24 months of the preceding violation. Now, when it comes to actually issuing these citations, these statutes can be very clear about what information is required in writing. So you must list the name and address of the person cited, the nature of the violation, the location and time of the violation, the amount of the civil penalty along with the manner, location, and time in which that penalty must be paid, and then a notice stating that a person has the right to elect to stand trial so long as they've done so at least 5 days before the date in which that payment is due. And then last, a warning that failure to pay that civil penalty or contest liability in a timely manner as provided would be an admission of liability, and it could result in an entry of default judgment for the violator. So as far as procedure is concerned, as far as citations, process, trial dates, how's that going to work? Well, the person who writes the citation, they're going to retain a copy of that, obviously. If a person elects to stand trial, he or she has to send the notice to stand trial to that county health officer designee. Then the county health officer designee would forward the notice and copy of the citation to the appropriate district court, so whichever jurisdiction in which this took place. The district court would then schedule the case for trial and notify the defendant of the trial date. And then the district court ultimately is required to remit certain collected penalties. And there are some new reporting requirements and obligations, and so I just want to really stress here, at the local health department level, folks would be required to report violations to the comptroller's office. And one question that's popped up quite a bit is, how does this law interact with the criminal law 10107? And so essentially, enforcement of either precludes enforcement of the other. And so what I mean by that, for example, is if you're enforcing this civil penalty, this law, then you can't go ahead and also charge for the misdemeanor under criminal law 10107 and vice versa. You can't start with the misdemeanor under criminal law 10107 and then come back and try to also get them under the civil money penalty law here. All right. And I also just want to say we will be likely putting together some training and some materials in the future in the next couple months because, like I said, this does go into effect October 1st. And so we will be providing some additional guidance. But in the interim, if you do have any questions or concerns based on anything I said, or if you've already heard me talk about this, some of you may have, please feel free to reach out to us so that we can get going with this and let folks get set up before this actually goes into effect October 1st. And with that, I'm going to turn it back over to Kathy to discuss the other bill which passed.
Thank you, Brooke. Sorry, you had your little map that you could do. Brooke had a lovely map that she forgot to show you guys, but it'll be on the slides that get posted. Excuse me. Again, just briefly here on House Bill 747. This one actually goes into effect July 1st because it's a fiscal bill, and fiscal bills go into effect on July 1st, but it aligns the DHMH, or actually it'll be called the Department of Health soon also. That was one of the bills that passed, just changing the name. But it aligns their baseline tobacco study with the criteria used in the youth tobacco survey that CDC does every other year to include essentially to include all high school students, even if they're 18. So currently the Maryland study will only survey students who are under 18. The CDC, however, surveys all high school students. So there's a bit of a disconnect between the data that we're collecting. So to align that data, both for evaluation purposes and for research purposes, the baseline study has been changed so the criteria matches that of the CDC. So now we'll be comparing apples and apples with the CDC data instead of apples and oranges. The other thing that it does, and there are a couple of things, but the other thing to note is it removes the requirement that local public health cancer grantees dedicate at least 60% of the funds that they receive to cancer screening, diagnosis, and treatment. It allows DHMH the authority to change that percentage for whatever's appropriate for the particular grant or for the particular grant period. So that had been a constraining element for some of the grantees, and it's alleviating some of the pressure for some of them so that they can fund things that might actually be more effective for tobacco control and public health, but didn't fit into any of these categories that they had to spend that 60% in. Seeing no questions, we're going to start talking about the failed bills, and I'm up first. So I will take on a few here. Again, a couple of these are actual victories instead of defeats, but the term failed is, at least in my world, being a professor, a very harsh one. But we're glad that some of them failed. But House Bill 354, excuse me, also cross-filed as Senate Bill 624, would have prohibited the use of ENDS or electronic cigarettes in any indoor area open to the public, including bars and restaurants, essentially including e-cigarettes in the Clean Indoor Air Act. the Comprehensive Clean Indoor Air Act that was passed in 2007. This bill has been seen before, and I suspect will be seen again, but it did receive an unfavorable report in the House Economic Matters Committee. Subsequently, the cross-file bill in the Senate was withdrawn. So I think the takeaway here is perhaps until we have more evidence based for the impact of exposure to secondhand vaping, we're not likely to see, I think, budging on this. There are local jurisdictions, there are, states around the country that have included electronic nicotine delivery systems in their Clean Indoor Air Act, but I think in Maryland it's going to take us a little bit more time to gather the research. And also, I think there's some notion of whether these products are actually, going to become a mainstream product with some staying power, or is it trendy, like the fidget spinner in my house, but is it trendy? I don't think that's the case. I think that it's actually a product that has, a pretty big market share for a new product and is going to stick around, but I think the legislators aren't necessarily sure of that and don't want to be overly heavy-handed with regulation of the product. The other thing to mention here is, and we tell anyone who contacts us about this business-wise, if they want, any business that wants to prohibit the use of ends in their location may, just like they could have prohibited smoking before the Clean Indoor Air Act, they can prohibit vaping. Whether it's a bar, a restaurant, hotels, or a workplace, they can certainly prohibit the use of this product there on their own. They don't need a law to do so. So I think that's an important thing to mention here. Then another Clean Indoor Air Act related bill was House Bill 597. There was a lot of effort put on this bill by Mr. Zimmerman and who has been, I think, working on this issue broadly. But as you may be aware, if you travel, smoking is prohibited in, smoking is prohibited, wait a minute, I have the wrong description up on this bill. I'm sorry. The purpose of the bill is misstated here on this slide. This would have repealed the exception for allowing smoking in some hotel or motel rooms that is allowed by the Clean Indoor Air Act. It has nothing to do with e-cigarettes. It's totally 100% my fault. Clearly cutting and pasting and not pasting the right thing. Brooke's making a face at me, and it's fine. See, I make mistakes, and so it's all okay. In any case, I'll fix this before they get posted, but it would have closed that exemption so that all hotel and motel rooms would be 100% smoke-free all of the time. And it did receive an unfavorable report in House Economic Matters Committee. The important thing to note here, again, is that many hotels of the larger chains have gone completely smoke-free. They do not permit smoking in any of their hotel rooms at any time. So I'm sure for those of you who travel, you find those. Certainly I know for me and my family, when we travel, we only stay in properties that are like that, because no one wants to, if you're not a smoker, you certainly don't want to stay in a room that had been used for smoking or be next to one or around one where there is smoking. And so I think the trend in that regard is, consumer demand has pushed those kind of larger chains, forward on this in any case. So sorry about that mess up with the slide. But the House Bill 500 is the next one that I'll talk about, and this one actually would have, how to correctly state this. Every time I went to say it, I said it differently before, but it permits in a lease for a multi-unit dwelling or for a condominium bylaws to prohibit the use of combustible tobacco products, essentially smoking tobacco products, including in the individual residential units. So currently under the Clean Indoor Air Act, the common areas, because they are technically workplaces, should be smoke-free in all condominiums and multi-unit housing, but that does not impact the ability to use smoked tobacco products inside the individual units. And this was really a law that would make affirmative and make super clear that a condominium board or a multi-unit housing, owner could impose those restrictions inside individual units. To be clear, the LRC has been saying for as long as I can remember that the law already permits this. It is, pretty clear the state law does not prohibit or restrict any condominium, homeowners association, or property owner from limiting smoking on their products. So and there are examples of many, again, smoke-free properties. I think all Bozzuto properties in Maryland are smoke-free, and there are many other examples of, leading residential rental places being smoke-free, and there are a handful of condominiums that have and are considering restricting smoking even in the individual unit. So this bill would have just said what is already in the law, but it would have, so why pursue something? Why are folks pursuing something that's already, kind of, at least from our estimation, clear in state law? Because there are boards, I can tell you, who have had some hesitation in moving forward with such a restriction, because their lawyer has said, oh, I don't know, we don't know what the law is. I mean, I've seen these communications from these lawyers telling them it's not clear, we're not sure, and so they're afraid. They don't have the resources to get sued and deal with that lawsuit, and so they'd like to have this affirmative statement, in the law that they have the ability to restrict smoking in individual units. So I think we could potentially see that one come back up. Now, I think this is my last one. Yeah, so this is my last failed one that I'm going to do, and then you can hear from Brooke. Is that yours?
Yeah, that was yours.
Oh, sorry. Sorry. I thought it was mine, Brooke. Anyway, insert laughter there. There was a time for laughter. If you saw Brooke and I doing our Laurel and Hardy here. House Bill 541 and Senate Bill 474 would have created a separate account in the Cigar Restitution Fund that could be used for substance abuse disorder treatment, and would have authorized the governor to transfer up to $5 million from the CRF to the Behavioral Health Administration annually. So what does this mean? It would have been taking up to $5 million from the CRF to be used by the Behavioral Health Administration for substance use disorder treatment. It didn't require that, but really allowed the governor, allowed the governor to take CRF funds for that purpose. And this failed. Clearly, this is, we've seen this bill before, we've seen efforts like this before. This is a response to the very serious epidemic associated with opioid use and abuse in our state and in this country. As I said before, this one kind of splits the baby, right? It received, neither committee voted on it, the Health and Government Operations Committee and the Senate Budget and Tax Committee. The hearings are tough because you have public health folks on both sides, folks who are saying tobacco is a problem, it's going to remain a problem. If you siphon funds away from it, the problem will grow. But public health folks at the table saying substance abuse is a serious problem. We're at epidemic proportions with it with respect to opioids in this country. We need money to help resolve that. And I think, again, I'll sit firmly on the fence and say, yes, there is definitely more money needed for substance abuse treatment, and yes, there is definitely more money needed, and we need to retain the funding that we have to address the tobacco problem. So I wouldn't be surprised to see this one pop back up again and create that kind of conundrum for the rest of us. So actually, is this one? It is. This is my last one. So I had so many, I forgot. So the Smoke-Free Multifamily Housing Promotion Act, not similar to substantively, but relates to actually encouraging multi-unit housing properties to go smoke-free and allowing a grant program to provide them with financial assistance if they do adopt smoke-free policy. So it was actually using money to incentivize multi-unit properties to go smoke-free. It didn't, it would have encouraged the governor to fund such an effort. Again, there wouldn't have been a requirement for the governor to do so even if the bill would have passed. So there may have been no funding under the bill even if it passed, but it didn't. It received an unfavorable report from the Environment and Transportation Committee in the House. To be honest, once we saw this bill and knew that there was funding involved in it, we thought it would be dead in the water. The governor has been pretty clear about expansion of funding, and I don't know that the governor would have funded anything even if this bill would have passed. So I think that other encouragements for multi-unit housing properties to go smoke-free can still be used even if we don't have this particular financial incentive. That is, number one, consumer demand, because we do know that the overwhelming majority of folks in this state do not smoke, or even among smokers, that they don't smoke in their own home and don't want to be exposed in their own home, or have their family who are non-smokers exposed in the home. There are savings that can be negotiated with insurers. There are the safety, benefits received, reduction in fires. There is the benefit of having fewer neighbors complaining about each other and the smoking that's going on. So there are a lot of other reasons for smoke-free properties, for multi-unit housing properties to go smoke-free, and without the financial incentives, we just need to be mindful of encouraging them for those other reasons. And if anyone has any questions about the smoke-free properties, first visit our website about Maryland smoke-free multi-unit housing, and then certainly give us a call if you have any questions and want to encourage folks in your jurisdiction to take the next step. Okay, so now I am actually officially turning this over to Brooke to talk about the two failed bills that are really happy failed bills.
Right. All right, so these next two bills, these would have permitted similar laws in Frederick and Harford County, and like Kathy mentioned earlier on, really this is successful that this failed, as odd as that sounds, because they would have weakened the Clean Indoor Air Act in those jurisdictions. So essentially, there are a few differences. The bills lay out how these two would differ, but I just want to explain very briefly what they each would have been. So the one in Frederick, HB 396, and also in the Senate is SB 326. This would have established a cigar shop, beer, wine, and liquor license. And so in order to qualify for this license, a shop would have been required to have 70% of daily receipts from the sale of cigars. And it would have allowed for beer, wine, and liquor to be sold to customers for consumption only in the smoke shop at this location. And so both bills in the House and the Senate received unfavorable reports for that. And in Harford County, this is very similar. There are some minor differences, but this would have established a Class B cigar shop, beer, wine, and liquor license. And in order to qualify for that, $500,000 in sales from tobacco-related products would have been required. And non-tobacco products couldn't have exceeded 30% of the gross yearly sales. And in that particular instance, it would have been that alcohol sales would have been permitted between 4 p.m. and midnight if a particular retailer had this license. And so in the House, it received an unfavorable report, and there actually was no vote on this bill in the Senate. All right, so this next bill, this would have limited the use of an open flame in residential dwellings. And this was HB 600 and SB 175. Our law clinic actually had a few students work on this, and one ultimately testified in the General Assembly. This failed, and this was sort of more what I would call a common sense bill, and I'm going to talk about that a little bit. So essentially, the goal was to limit the risk of damage to property, persons, healthcare workers, which may be caused by smoking near a home oxygen device. So medical oxygen itself isn't flammable, but it can cause fires to start at lower temperatures and burn faster. So there's really no safe way to smoke in a residential dwelling when medical oxygen is in use. And so some of the testimony during this session revealed that in the last 5 years, 9 people have passed away in Maryland due to home oxygen-related fires. And the majority of those were caused by a resident smoking near a medical oxygen device that would have taken place in a multi-unit community. So in short, this would have banned the use of an open flame, including lit tobacco products, in a residential dwelling or within 20 feet of a residential dwelling in which medical oxygen would have been used. It established a civil penalty scheme, but unfortunately, both the bill in the House and the Senate received unfavorable reports, so those did not go through. And this next bill, this dealt with tobacco control funding, and this was something that the Maryland Statewide Tobacco Control Coalition did quite a bit of work on. It was introduced in the House as HB 703 and in the Senate as SB 113. And here, the goal was to increase funding from $10 million to $21 million, even though the CDC recommends about double what they were even asking for. what the money would have been used for would have been for media campaigns aimed at reducing smoking initiation and encouraging smokers to quit. Other media campaigns aimed at educating the public about the dangers of secondhand smoke exposure, enforcement of existing laws banning sale to minors, promotion and implementation of smoking cessation programs, and implementation of school-based tobacco education programs. But ultimately, the funding for these items is going to remain at $10 million this year because this did not pass. Neither bill received a vote in either committee in the House or the Senate. All right, and so this is definitely my last one. I'm going to talk a little bit about SB 669, and this is the Tobacco 21 bill. So many of you have heard about this, but in recent years there's been this Tobacco 21 movement. And so the idea behind this is that if the minimum purchase age for tobacco products is raised to 21, then youth about 15 to 17 will never begin smoking. So of individuals who are daily smokers, about 90 or 95% of them begin smoking before the age of 21. And so obviously reducing the youth smoking rate will result in a lower smoking rate for the entire following generation, because only a small percentage of daily smokers actually begin smoking after the age of 21. And so this would have raised the minimum age to purchase products from 18 to 21. It did receive an unfavorable report. I anticipate that we are going to see this one again. In the past few years, we've seen this in dozens of municipalities across the country, but most recently we had California, Hawaii, and then just a few months ago, Washington, D.C. passed this. So this is a trend, this is a movement, and we anticipate that we will see this again. And at this time, I'm going to turn it back over to Kathy, who's going to talk a little bit about 2018.
2018, that sounds crazy. So first, all of you, probably most of you on the call, if not all of you, are part of our biweekly calls that we do during the course of the legislative session. If you're not, we have these biweekly calls during the legislative session. They are typically we do them on Mondays because there are no hearings on Mondays, and so it makes it easy for us to make sure that we're going to be available early in the afternoon. So you can contact Melissa Sager, one of the staff attorneys here at the Legal Resource Center, and she can get you on the list if you're not already on the list to be included in the legislative updates that we do during the course of the session. They also that you'll also be included then on receiving our charts. And so in addition to the calls, our law students during the course of the semester, with the supervision of the attorneys in the Legal Resource Center, develop a chart tracking tobacco-related legislation that's mostly relevant for this group, but also injury prevention, environmental health, behavioral health, really any public health issues. We're taking a look at any changes to the Health General article. And they create a beautiful Excel spreadsheet with tabs, so you can just go to the ones that you're interested in. But for those of you who are on the call and have been receiving these, or folks who haven't, if there are other folks in your office who are interested in the stuff outside of tobacco, certainly let them know to communicate with Melissa, and they can get on our list for the biweekly calls as well. They are interactive, and so they're open mic calls, and you can participate as well, ask questions. Often people will use that forum to try to talk with others who are interested in potentially collaborating to work in support of or in opposition to a particular bill. So you want to get yourself on that list if you're not on there already. What to expect is really, a difficult thing to ponder. It will be the final year in this 4-year legislative term. So we tend to see less risk-taking by legislators because they'll be coming up for re-election. We tend to see the governor also playing it a bit on the safe side, typically at this term as well, because he too will be up for re-election. And so I don't expect to see anything incredibly dramatic. Whether there are some of the bills that failed that we were talking about here get reintroduced, I think Tobacco 21 we could likely see come back. I think the some of the others related to the CRF funding for behavioral health administration, the multi-unit housing. I don't know exactly what it would be, but that kind of affirming the power of multi-unit housing to go smoke-free could come up again. But as of this time, we are not aware of any kind of unique or different types of bills coming in. The one caveat I'll issue here is, as I mentioned, as an aside earlier, the current administration has kind of put the reins on the FDA with respect to enforcement of the deeming regulation, the regulation that brought into FDA's regulatory power all tobacco products, including ends, at the federal level. And for FDA regulatory purposes, ends are considered tobacco products. And so we'll see what the FDA is directed to do, whether that deeming regulation ever goes into effect and is enforced or is withdrawn or tinkered with in any way. That may cause states and local jurisdictions to want to take action where there will be gaps if the full deeming regulation is not put into effect. So again, I don't want to prognosticate on that. I'm hopeful that the FDA is allowed to enforce this rule that took quite a long time to get promulgated, and I think is just the essentials of including some hookah and other kind of currently uncovered products, including cigars, into the jurisdiction of the FDA. So other than that, don't know what's ahead in 2018. Just a tiny primer for those of you, probably everyone on the call already knows this, but the legislative session starts in, just making sure. Sorry that I wasn't answering questions as we were going along because the screen makes it difficult to see them here. I'm actually looking through them now. Yeah. I can't show unanswered. I can't. Brooke mentioned that local jurisdiction. So someone asked a question about, I'm sorry that we didn't check the questions box, whether under the civil enforcement statute, HB 185, and Brooke said it's up to you whether to issue a citation under that new provision as a civil citation or under the current criminal law article 10-107. And you could decide that, yes, you could decide that your program is going to issue them under the new civil citation or under the criminal or on a case-by-case basis. You could adopt a policy where if it's a repeat violator, your second violation notice to them is under the criminal law statute. So you have to pick one each time you're issuing a citation, but you can be fluid with respect to what type of citations that you issue to, at a particular time. I see Benita chiming in with that the Frederick County and Harford County specific bills were times when the hospitality industry, the food, the restaurants were on the same side as the tobacco control people, and it was a funny thing to go up to the table, right, with them. In any case, so I think those were all the questions that were in the question box. But for those of you who aren't aware, the Maryland legislative session starts in early January, runs through mid-April. It's a 90-day session, but most of the work with respect to kind of important bills or really any bill that you really want to make sure gets on the table is done in what's called the interim, and that's now. So if you are thinking that you want to work on something at the state level, or a particular one of your legislators has contacted you to ask what you might be interested in them introducing for the 2018 session, and you'd like our insights, certainly let us know. We can provide you with what we know is going on around the country, with the evidence base for such laws, and any other support that we might be able to provide to you leading into the 2018 session. So don't be strangers. If you want, you can certainly reach out to your legislators and say, are you interested in working on any tobacco legislation? Do you want to sit down and talk about that? Because they may. They may not, but they may, and so it's an opportunity for you to do that. In the beginning, or sometime in the fall, we will host a webinar that's going to give you much more details about how a bill becomes the law in Maryland, and the do's and don'ts for folks who want to be able to assist legislators but don't want to cross the line into lobbying. So that'll come up in the fall. Again, if you have any questions in the meantime, you can certainly reach out to us. But we'll go through the whole, I might sing Schoolhouse Rock, how a bill becomes a law to you, but I'll be on mute, so you won't be able to take. I'll be sitting here in my office by myself, but we'll undertake that then. So I don't see any other questions coming in, and so on that note, we are going to end the webinar and give you 7 minutes back in your day. Thank you so much, everyone, for attending. Take care.